You
May
may
it
proceed.
please the court, my name is Jonathan Harwell. I'm here on behalf of the defendant appellant Rusty Patterson. If I could reserve 4 minutes of my time for rebuttal.
Yes.
I have two claims I'd like to talk about today. One is maybe a more pedestrian claim, but I think is very important in its own right, and that is the sufficiency of the evidence as to value. Not to go through the facts, this was a exchange of a motorcycle that ended up with the defendant driving off the motorcycle without the permission of the person who thought he was selling it to the defendant. It was charged and convicted and sentenced on the theory that the motorcycle had a value of $2,500 or more, and so it became a Class D felony. The argument that we have raised is that the evidence of that was not sufficient, and it would start, not to say the obvious, start with Jackson versus Virginia. We are talking about whether a reasonable jury could not just conclude that the value was more than $2,500, but conclude beyond a reasonable doubt. And on this issue, we are not talking about conflicting testimony. We're not talking about credibility of witnesses. We are just looking at the evidence that the state introduced as to value and whether that would clear up any reasonable doubt as to the value of the motorcycle. The one fact that is undisputed and I think is absolutely key in this case is the obvious way to establish value was to ask Mr. McGeorge, what was the motorcycle worth? If that question had been asked and the answer had been $2,501, then I wouldn't be here arguing this issue. For whatever reason, the state did not ask that question, did not ask him really any questions about.
I mean, I don't know if it was the question, but didn't the motorcycle resell for $2,800?
Yes.
Okay. Why wasn't that sufficient?
Because there was essentially no evidence linking that resale back to the value at the time. This was
at the time of the taking.
Yes.
Okay.
So this was a very short portion of the transcript. It was established that at some point, so Mr. McGeorge says a couple of months later, he started driving the motorcycle again, and then he sold it after that. So whether he sold it a couple months later, sold it a year or two later, who knows?
Well, wasn't the proof at trial that they agreed to $3,000?
Yes and no. There was discussion of $3,000. It was in the context of I want to look at it, right? The defendant had not seen the motorcycle, so the $3,000 was a even on its face, it's sort of a I want to look at it, and if I want to buy it, then that's the amount I would pay.
I understand. I think at first he was going to pay him $2,800, and then they agreed to $3,000.
That the defendant was agreeing the motorcycle was worth. That was the number he was offering to get Mr. McGeorge to bring the motorcycle to the place he could take it.
Why can't that be considered what the motorcycle was worth? Why, are we not mincing words here? If the defendant agreed that this is how much I would pay for it.
The point is, the state is saying he never intended to pay for it. He wasn't agreeing this is what he was.
What does that matter?
He was pretending to.
Right, he was going to steal it. But how does that affect the value?
So if I pretend something is worth something, that's not actually evidence of its actual value. That's evidence of me pretending to get someone to bring something to me.
But the victim believed him.
Yes, and that's why it's a crime. But that doesn't actually shed any light on the sort of abstract question on this day, what was this motorcycle worth?
But wasn't that the jury's determination? I mean, the jury heard this proof, heard all these figures thrown out, and they determined that the value was more than $2,500 or more, based on the figures that came out from the testimony.
Yes.
Okay.
And it's our position the jury got it wrong and that the jury acted unreasonably. That no one, no reasonable juror, no attorney, no anybody looking at this evidence can say I know that motorcycle was worth more than $2,500 on that day, and I have no reasonable doubt as to that.
So it was sold for over $2,500 after it'd been wrecked?
Yes, but also, and this is what I hadn't said, after it had been repaired. In the record, I had said that the battery was repaired. I think maybe the battery was not repaired, but it is clear that Mr. McGeorge testified that in that time period after the motorcycle was recovered, that he repaired it in a number of ways. And so, again, if it then sold for $7,000, maybe I couldn't make that claim. But if the cutoff is $2,500 and you have a motorcycle that has been repaired, maybe improved, maybe not improved, who knows? And time has passed, maybe that affected the value, maybe it didn't, who knows? And it's sold for just over that threshold. I don't think that you can look at that and say, I know beyond any reasonable doubt that it had to be $2,500 or more, could not possibly be only worth $2,400. And that's what a jury would have had to be able to conclude.
Almost sounding like you want it to be beyond all doubt, because you're getting really down into the minutia of whether the battery was repaired and whether that constituted a certain amount, and all of these things are really, you're asking us to get into jury determinations, and that's what's a little off-putting about your argument.
I don't think it's any doubt. I think it's a reasonable doubt to say something is worth $2,800 after some repairs have been done to it, and we don't know what the value of those repairs are. Is it reasonable to think that might not prove that it was always worth more than $2,500?
When did the victim purchase the motorcycle?
6 years earlier, I think for $6,000.
$6,000. Is that a relevant fact?
It is.
It's not dispositive. Is it relevant?
It is relevant with vanishingly small weight, I think.
With caveats, right? I mean, that is a fact the jury could consider in the totality of the circumstances.
Yes.
Okay. All right. So if we have a purchase price, we have a sale price, we have a negotiated price, those are all facts from which a reasonable juror could draw conclusions and inferences, are they not?
Except I don't mean to mince words.
Sure.
We don't have a negotiated price.
Okay. I mean, your argument essentially is that if the defendant were to offer $250,000 to get the motorcycle to the parking lot, that would not be evidence of an A felony. I mean, that's essentially what you're arguing,
correct.
Right? Okay.
And it is the state that has taken the position all along. This is not, he agreed to buy it and then at the last minute decided, actually, I just want to run away with it. He never intended to buy it under the state's theory. The agreement to the $3,000 was a trick in the state's theory. So there was never, a meeting of the minds could somehow be relevant evidence of fair market value. Here, there was no meeting of the minds. Under the state's theory, the defendant, it was all imaginary.
So the seller's willingness to sell the motorcycle at that point for that amount, is that a relevant fact? Not dispositive, but is it a relevant fact the jury could consider?
I would say no.
The fact that the seller's willing to let the bike go for $3,000 is not some evidence of the market value being at $3,000?
It is evidence that the market value was not more than $3,000.
Okay.
But
All right.
Otherwise,
So
the seller wouldn't have let it go.
So that's a relevant, and Judge Campbell, I'm sorry.
No, that's okay.
So we have here then at least some relevant facts. We have a purchase price, not dispositive. We have a seller willing to sell for a particular price. We have an actual sale occurring after some other time. Each one of those has warts on it, obviously. Could a reasonable jury take those facts together and draw reasonable inferences from them to come to evaluation?
No.
Okay.
I mean, a reasonable jury, I think, could decide this was worth more than $500 and probably worth less than $10,000. But could a reasonable jury look at this and say, it's above $2,500 and not $2,400? I don't think they could say that without having a reasonable doubt.
Judge Campbell, I'm sorry.
Well, no, just to follow up with what you were saying, it's not significant, or it's not, I think you would agree it's relevant that the owner turned down a $2,800 offer and said that wasn't sufficient. So that he wasn't going to let it go for less than, for $2,800, based on the proof.
I don't know that I read the record that way. There was this back and forth of 5,000 and 28, and okay, I'll offer 3, and
He wasn't going to let it go for 28, because I think your client at one point had offered him 28. And he said he wasn't going to let him have it for 28. And they talked about 3,000, which he said, it appeared to me that they seemed like that was an agreeable figure, and he wanted to come do a test drive. And then, of course, he took off with it. But all of those factors were in the record for the jury to consider. And you're saying it was unreasonable for the jury to take those numbers and make a conclusion that the value was over $2,500?
yes, it was unreasonable for them to conclude that beyond a reasonable doubt. And the record will reflect it. In my view, there was a negotiation with lots of moving parts. It was a pretend negotiation, but it was also incomplete even on the side of the seller. When they were talking about prices, he was saying, well, I'm not sure what the exhausts are stock, and I'm going to look and see if I have some, and it was all sort of leading up to actually meeting to evaluate. I do want to move to the other issue because I think it is important as well. Before I make the legal argument with the court's indulgence, I would like to offer an analogy. Let's say we wake up one day and TDOC says, actually, we're going to close some prisons. We've got too many prisons. We're going to close some prisons, and we recognize that's a problem. From now on, we're only going to accept prisoners from Middle Tennessee, West Tennessee. Anybody sentenced to TDOC from East Tennessee just has to go on probation. We've closed the prisons. We don't have enough room for everybody. We take those people just get probation. That wouldn't fly. It's not a perfect analogy, but that is sort of the essence of what bothers me about this. I want to be a little more clear maybe than I was in my brief of what the error is. The error here is that Mr. Patterson was eligible by statute for consideration for community corrections.
I'm going to stop you right there. Did you request community corrections from the trial court? Because my review of the record shows you did not. It was discussed. The issue that your brief discusses and that I can sense is a real problem here, according to you and the trial court, but you didn't request it. So the trial court never went down the considerations for us to even get to the merits of what you're talking about.
It was not phrased as a direct request. The issue was raised. Defense counsel could have said nothing, right?
What issue was raised?
The defendant's eligibility for community corrections.
Where?
That is what defense counsel says. My client is eligible for community corrections, but there's not a program here. The judge then says, you would have been eligible for community corrections, but there's not a program.
Is that properly preserving the issue? Because don't we have to go through certain factors to determine whether or not he would have even been eligible or would have been a successful candidate? Because I'm looking to see his background, whether he would have qualified. Even though he's eligible doesn't necessarily mean that he would have been accepted or approved by the trial court for community corrections. That's my first, that's what we always do when we're reviewing these issues. And so because there was nothing in the record for me to really look at, I don't know if it's properly preserved. There was this just off the top comment by defense counsel as well as the trial court that, hey, something's going on with these programs. We no longer have these programs here.
So it's our position that that is enough to preserve. This is a sentencing claim. The court can review challenges as to the manner of sentence.
Would you agree with me that just because he's eligible does not mean that he would have been accepted by the trial court?
Yes.
Okay.
And so the error, and I think I clarified this in the reply brief, maybe I didn't do it well in the brief. The error, we're not saying that Mr. Patterson had to be placed on community corrections. We're saying the trial court had to consider that. And the trial court's error
Well,
maybe
the trial
imposed on the trial
only-
court.
The trial court wasn't required, unlike with alternative sentencing, to do it sua sponte. Defense counsel had to raise it and ask for it. That's what our case law says. So because defense counsel did not ask for it, the trial court wasn't obligated to go down the road and go through the community corrections analysis.
And I think, maybe I misunderstood this, but when I looked at this, it looked like defense counsel's position was, we can't ask for it because it doesn't exist.
That's certainly one way to look at what defense counsel said.
Okay, because the judge was saying, like, unfortunately, these programs are here. It wasn't that he asked for it and he didn't get it. It was, he was saying, we can't get it because it's not available.
And that's wrong, that you can't get it because it's not available.
But then it was
it's
never
practically true.
fleshed out before the trial court.
And I'm going to give you your time, Mr. Harwell, because I know we've asked you a lot of questions. The other thing, even if I was convinced and as frustrated as you are about the lack of programming here, what remedy do we have as a court? What can we as a court do, even if we were to reach your question?
So I think the specific remedy I'm asking for is the courts to say that the trial court erred in not conducting the analysis of whether Mr. Patterson should be sentenced to community corrections and
Okay.
send it back for the court to do that. Maybe
even,
the court
even when you didn't ask for it to begin with. You didn't ask for it.
So my general thought about waiver is waiver is not about the form of the objection, the form of the exception. Waiver is about,
I'm afraid
did I
our
bring...
Supreme Court disagrees with you greatly. So that is just wrong.
There is a rule saying formal exception is not required. What is required is bringing an issue to a court's attention. So it's not, you're not sandbagging, you're not waiting till after the fact, you're not Monday morning quarterbacking. Here, absolutely do I wish the defense counsel had said, we demand community corrections. But that wouldn't have changed anything because defense counsel identified Mr. Patterson is eligible for community corrections. The trial court ruled, I have no option. You can't get community corrections. I think that is enough to preserve the issue. Again, do I wish it had been phrased exactly the way that I put it in my brief? But I don't think that this is not.
Yeah, you have, your brief is very well written, okay? But the issues are just not what was presented to the trial court. So you really have put us again in a position to have to guess what the trial court would have said had you raised all these issues before the court. Now, I'm going to have to cut you off.
Can I have
Please,
just a little
Judge,
leeway
yes.
on this? And I'm sorry, I won't take as long as I usually do. Is the argument fundamentally that either all 95 counties have to have community corrections or none can? So for example, sitting on the trial court bench in Hamilton County, every year I was asked to write great things about my community corrections program because it was great. But that was sent back to TDOC, presumably to the legislature somewhere, to reauthorize the program. If for whatever reason Hamilton County's program went out of business, does that mean that Bradley County's next door is unconstitutional? I mean, is it really an all or nothing here that simply because the program doesn't exist in Knox, that somehow that affects the constitutionality of what's going on in Knox simply because I have one in Hamilton?
So I think the answer comes from Tester, in which the court addressing whether DUI could be served in periodic confinement in 3 counties. The court talked about it's just rational basis review, but there has to be some reason to differentiate those 3 counties from the rest of the county.
Okay, and so funding could be one of those, right? I mean, all 95 counties don't have a drug court. So are drug courts unconstitutional simply because they may not be available in Marion County, but they are in Hamilton? Surely not,
that might
right?
be a rational basis for distinguishing those.
Okay, all right, that's fair enough, okay.
But I don't think we have that here. We have TDOC deciding essentially to eliminate them with.
And again, we can't tell TDOC, we don't have jurisdiction to tell TDOC what to do we? I mean, we don't have that. You're asking us to do something that we don't have the ability to do. And I don't know if you're just doing, not just, I don't mean to phrase it that way. Maybe you're trying to go up higher. That's the only way I can see it, because I didn't see a jurisdictional basis for us to grant the relief that you're asking for. You asked in your brief to create, to ask the trial court, when you didn't ask in the beginning, to create a program out of thin air. And the trial court doesn't have the authority to do that, nor the resources. So again, we've gone way too long. I'll let you have your rebuttal time. General.
Good morning. Good morning, Your Honors. May it please the Court. Garrett Ward on behalf of the state of Tennessee. Your Honors, I will, like my friend on the other side did, devote my time to the sufficiency issue in this community corrections related issue. There is a jury instruction issue presented in the briefs. I'm happy to rely on my brief for treatment of that issue unless this Court has specific questions about it. Regarding sufficiency, I interpret this issue as being cabined solely to value. There's no serious dispute. I think that all the other elements of theft are rather easily qualified. But as to value, I'd point the Court to 4 specific pieces of evidence that have been, in varying degrees, already discussed in this argument. One is the stolen property here was a motorcycle that was put up for sale on an online marketplace. The sale price when it was listed was $5,000. So that's the first piece of evidence, is this list price. The second piece of evidence is what I'm going to call the sort of agreed sale price between the defendant and the victim of $3,000. That's the second piece of evidence. The third is the ultimate resale price by the victim after repairing some damage caused to the stolen motorcycle by the defendant for $2,800. And then the fourth is the victim's initial purchase price of this bike for $6,000, I believe, in 2015, so about 6 years before this taking occurred. And Your Honors, I'd suggest to the Court that viewing these 4 pieces of evidence in their context, which I'll discuss, viewing these 4 pieces of evidence in the light most favorable to the state, a jury could rather easily conclude this motorcycle is worth.
As a former prosecutor, it is fundamental in every theft case to establish value.
Absolutely, Your Honor.
And your friend on the other side, his power question wouldn't even be here. Mm-hmm. Fundamental. What was the value of the motorcycle at the time? Off the top, it's like venue. Did it happen here? What happened here? You're asking us to extrapolate numbers based on a variety of things, and I'm not saying they're not there, mm-hmm. but this is elementary. Do you agree?
I do, Your Honor, and not to sound too, and not to necessarily just repeat the words of my friend on the other side. I certainly wish that below the state had asked that exact, had said something slightly different than what it said, had asked that exact question. If I were to draw up a playbook for how to establish value in a theft case, it would almost certainly involve asking the victim, what do you think this is worth, directly on the stand. We didn't have that here. What we do have are these 4 pieces of evidence, which, while they are not exactly the same as this direct question, they do certainly speak to what Mr. McGeorge, the victim in this case, thought this motorcycle was worth. So they really do get to the same sort of core concept of what is the fair market value of this motorcycle. Admittedly, it's not quite the same as asking him directly on the stand.
Fair market value is a value that's determined by an agreement between a willing buyer and a willing seller.
Certainly, Your Honor.
Typically, each one of these 3 or 4 categories that you denominate are not the same as market value. So we have some cases saying that it could be a relevant factor, and that's what I was discussing with your friend on the other side. But for example, listing the sale price at $5,000 is not evidence of what a reasonable buyer would enter into the transaction for. The purchase 6 years previous doesn't speak to today about what the value would be at the time of the taking. The negotiated price fictitiously negotiated price from the state's perspective between the defendant and the victim. It doesn't seem like that could even be reasonably thought to approach fair market value. As I tried to illustrate in the hypothetical, if it took $250,000 to get the seller to the parking lot, that's not evidence that we've got an A felony. And then, of course, the repairs are done to the bike afterwards, sold for $2,800 at that point. Not evidence of fair market value because it's not in the same condition. And so, do we have a situation where 0 plus 0 plus 0 plus 0 equals 1? Or does it still equal 0?
What I'd suggest, Your Honor, is that we don't have a situation where we're adding just a string of zeros together.
Okay.
Certainly, any one of these pieces of evidence, on an island on its own, if 1 is sufficiency, any one of these pieces of evidence on their own might not equal 1. I'll certainly agree with you, Judge Greenholz, on that point, that they're all relevant considerations, but not necessarily determinative.
We had the same thing in Robbins over the summer, where you had, in the context of a felony murder case, a truck is stolen. The truck is running. There's no value actually given to the truck at trial, the victim's truck. There is a bill of sale indicating that it was purchased for $200 there, and the court said the fact that you've got an actual truck, we know that it's running, but you have a bill of sale, doesn't get it over the $1,000 to be any felony. Just doesn't happen. How is this case any more different just because we have a fictitious sale?
Well, I'd suggest
Or fictitious negotiation.
it's different in a number of what I'd consider significant ways, Your Honor. One is, my recollection of Robbins and the bill of sale evidence is the same as yours is, Judge, that the bill of sale was for $200, so something that is significantly less than the figure the state's trying to get to. I do think that matters, at least to some degree, that the ultimate sale of the stolen property, or that the bill of sale for the stolen property is less than the value the state's claiming at trial.
Sure, and the court thought, in fairness, the court thought that was
That's certainly a
important,
relevant
right?
consideration. Here we have an ultimate sale for $2,800. I understand it's after some repairs. My view of the description of the repairs in the record is that they're repairs that are done by the victim himself to restore the bike to the condition it was in at the time of the taking. He's what Mr. McGeorge testifies to is not some like grand rebuild of the engine of this motorcycle. It's like, oh, the gear shift was bent because of the crash, so I replaced the gear shift. Some pretty minor things like that. So there's nothing in the record that suggests this $2,800 price is some way overinflated figure. So we do have this ultimate sale. Maybe on its own, not enough. Maybe on its own, not 1, but maybe it's 0.25. Well, we add that 0.25 to this agreed sale price of $3,000, which I want to note, and Judge Campbell brought this point up, this $3,000 price doesn't just spring out of nowhere. It's a roughly negotiated figure. This isn't the most, it's not as if there's a formal offer of $2,800 that's rejected and then a formal offer of $3,000 that's accepted. But essentially what this court will see from the Facebook messages where the defendant and the victim negotiated the sale is the victim wants $5,000. The defendant says, I'm not going to give you $5,000, maybe $2,800. And the victim says, oh, $2,800 is not going to do it. And then they say, what about $3,000? So there is two people, admittedly, one of them,
a willing buyer.
One of them is intending.
There's not a willing buyer.
Absolutely.
And so what we're
Your
left
Honor.
with is we have what the willing seller would accept. Once again, it's a zero when we're talking about fair market value. That also depends upon what a willing buyer would be willing to pay for it.
And Your Honor, if all the state had was this trick price, I think we might have a problem. But the fact that the defendant here is trying to trick Mr. McGeorge doesn't mean doesn't mean that the jury can't pay attention to what happened in this negotiated sale.
So
because
if the fictitious buyer would have met the seller at $5,000 and say, sure, I'll give you $5,000 subject to a test ride, would we say that's evidence that the motorcycle is worth $5,000?
I think we'd certainly say it's a relevant consideration.
Okay.
Like I've, I'm not trying to sort of hide the ball from the court. When this court's doing sufficiency review, we don't sort of silo the evidence and separate it from one another and say that any one piece of evidence on its own doesn't get us there. We have to look at it all together. So what I think the record will reflect is perhaps stronger than if Mr. Patterson had just met Mr. McGeorge at the $5,000 price. Even though he's trying to trick him, he does come in with this lower offer of $2,800, and Mr. McGeorge says, oh, that's not enough, so he comes back with a higher offer of $3,000. I understand the state's theory is that this was a trick, but I think my point is that this had to be a convincing trick. For this theft plan to work, Mr. McGeorge had to believe that he had a willing buyer. And I think we have very strong evidence in this case that Mr. McGeorge viewed Mr. Patterson as a willing buyer, because Mr. Patterson is pushing back on what he wants, is trying to get away with buying the bike for a little less, and there's some sort of give and take. So we have a very convincing hoax. And maybe on its own, because we don't have a willing buyer and a willing seller, maybe on its own, admittedly, that doesn't get us to fair market value, but we don't have that on its own. We have a list price, we have a resale price, we have this agreed price, we have a bike that we know is running, we have a bike that we know several years ago, admittedly, was sold for $6,000. And the ultimate question is, can the jury look at this sort of conglomeration of evidence and conclude, viewing all of this evidence in the light most favorable to the state, that this is worth more than $2,500, this motorcycle? I think they absolutely can. They have a running bike that just as an aside, is apparently capable of moving so rapidly that Mr. McGeorge can't catch up to it when he tries to pursue it while it's being stolen.
Well, in the pre-wrecked form, right?
And certainly,
at the time of the taking, right?
It's at least it is a running motorcycle. We have two parties who are at least acting like they are engaging in sort of an upfront, open and honest exchange of goods for money. This has to look convincing to Mr. McGeorge. Mr. McGeorge has to come to this Home Depot thinking he's going to sell this bike for $3,000 or he's not going to be there. So the defendant takes these steps to get to this value of $3,000 with Mr. McGeorge. When you combine that with Mr. McGeorge's ultimate sell for $2,800 with his list price of $5,000, and then his original purchase price a couple years before, admittedly there'd be some depreciation. None of these on their own equal one, but I think when you add them together, as this court does in sufficiency review, we do get to one, at least viewing all of them in the light most favorable to the state, which this court has to do for the purposes of sufficiency review. I'm happy to answer further questions on sufficiency. But if there aren't any, I'll turn quickly to this community corrections issue. And, Your Honors, this is a bit of an odd issue, and that much of what we're talking about, what my friend on the other side talked about, and much of what I'll talk about today, really has sprung up for the first time before this court. Is from the best of my recollection, the sum total of the discussion of community corrections below was Mr. Patterson's trial counsel saying, my client is eligible for community corrections. Maybe that on its own, maybe that would be enough to preserve the issue. But he goes on and says to the trial court, he's eligible for community corrections. He discusses sort of the fact that there isn't a community corrections program operational in Knox County at that time, and then says, and this is a quote from trial counsel to Judge Sword, I don't have a program to put before this court. And I think that's significant, Your Honors, because when we look at 4036-106 subsection E1, 106 is the sort of statutory, the offender eligibility statute. What trial courts are authorized to do under that statute is to place eligible offenders on programs that are provided in accordance with the terms of the chapter. And if what trial counsel is saying to Judge Sword is, who was the trial judge in this case, if what he's saying is, Your Honor, there is not a program that is provided in accordance with this chapter, I think that's a problem. And it sort of immediately causes a problem, at least as it comes to this court's ability to review any community corrections determination, because Judge Sword, after essentially just being told you can't place him on community corrections because a program doesn't exist, essentially says, I don't have any options. You're not probation eligible. A community corrections program doesn't exist for me to place you on. I have to sentence you to confinement.
Do you agree, is the trial court saying, are we to read from that he would have put him on community corrections?
I do not read it that way, Your Honor. What I read Judge Sword as saying is, if in a normal circumstance in sentencing a defendant like this, there would be a door A, which is confinement, and a door B, which is community corrections. Judge Sword is essentially saying door B isn't here, so we have to take door A. I don't think it's reasonable to construe what he says in the sentencing hearing as, but for the fact that this program isn't here, I would have placed you on community corrections. I mean, perhaps the reason he doesn't sort of cast his determination in that way is because the defense counsel wasn't really asking for community corrections. He says he's eligible, there isn't a program for you to put him on. And I think that sort of casting the situation in that light before Judge Sword really affected what it is that Judge Sword said when he was imposing sentence here. He was recognizing that I think all parties were agreed that there effectively wasn't a decision to be made. So Judge Sword made the only choice he could have, which was sentencing the defendant to confinement, because again, under the terms of 106E1, he can only sentence the defendant to a program that exists, to a program that is provided in accordance with the terms of the Community Corrections Act. If what he's being told by defense counsel is there isn't such a program, I'm not certain what the trial court is supposed to do in this situation.
So your friend on the other side, if I'm interpreting the argument correctly, I think what he's saying is that all 95 counties must have a community corrections program for it to be constitutional baseline. Some counties may not need to have one if there's a rational basis not to have one. A rational basis could be that we just don't have funding in a particular county for it. I may be completely misinterpreting that, but that's what I took from the briefing, from the argument. What proof is there in this record about there being a rational basis for not having a community corrections program in Knox County? And if there is not any evidence of that, what are we to make of that here on review?
So a couple of points on that, Your Honor. One is one of the things that I've perhaps have been that has been the most difficult in working with this case is the lack of evidence in the record as to what is actually happening in Knox County with regard to community corrections, and certainly what is the status of community corrections programs throughout the state of Tennessee at this time, and critically for these constitutional inquiries, why is what's happening in Knox County happening, and why is what's happening throughout the rest of the state happening?
So we don't even have, from that answer, I take it we don't even have information to be able to determine whether there's a rational basis for not having community corrections programs in Knox County?
Your Honor, I think my primary response to any of these constitutional challenges is that the defendant didn't present them
Sure,
below.
they're waived, and that's
so
what
so
you've
they're
argued.
waived.
Yeah.
And yes, that really does impact our record. We know very little about what happened to Knox County's community corrections program. I'm certainly not doubting the assertions by trial counsel or the trial judge that one doesn't exist. I believe that to be accurate. There is no discussion as to why that is the case. From my read of Mr. Harwell's brief, he ascribes much of this to some funding decisions made by TDOC in sort of their administrative capacity. But there's not really any discussion at the trial level to sort of establish this contention. So, Your Honors, perhaps in some way we don't have much evidence of what the rational basis might be. But I think the more fundamental problem is we don't even know sort of what the situation is. So we don't know how to ask for TDOC, what's the rational basis for creating this situation, if that makes sense.
Fundamentally, I think would the argument require us to make factual findings rather than just review findings by a trial court?
Yes. There are, I think, at least with respect to the constitutional issues, this case perhaps better than most others illustrates why waiver isn't some academic concept, why waiver is in many cases just a reflection of the differences between this court and a trial court. Trial courts are courts that find facts and make factual determinations, and then this court reviews those factual determinations, at least when doing constitutional challenge review like this. If you don't present a trial court with your factual contentions and allow your opponent to present the trial court with sort of their counter assertions with regard to the facts, and then allow the trial court to, as a finder of fact, weigh both sides' proof and make factual determinations and make findings, you really hamstring this court's ability to do meaningful appellate review. This court sort of depends on trial courts to say what the facts are in this case. And there's a great deal of mystery and murkiness in this case as to what is actually happening, why it is happening, and what connection any TDOC decision had to cause this situation. If that addresses your Honor's question.
It does, thank you.
I think briefly, I see my time is running short, but briefly I'd like to note something, Judge McMillan, I believe you touched on a couple of times. This is a very odd sort of question to be brought up in this case, because as I read opposing counsel's brief, his reply brief, and even listen to his argument, it sounds like his core complaint is a couple of years ago when TDOC amended its grant approval criteria, that it did so wrongly. TDOC is not a party to this action. This court is not typically a forum where we adjudicate the propriety of an agency's administrative decision-making. There might be forums to do so, but this really isn't one, and I think that is perhaps most fundamentally betrayed by the remedy that opposing counsel initially asks for, and that's creation out of whole cloth of a supervision program that doesn't exist. Unless this court has further questions, I would ask that you affirm what occurred below.
Thank you, General.
Thank you, Your Honors.
Mr. Harwell.
I'd like to take another stab at identifying the error in the remedy. The error, as I see it, is this. The legislature says that Mr. Patterson is eligible for consideration for community corrections. The trial court ruled that it could not consider Mr. Patterson for community corrections. That was error.
Well, let me stop you for a second, though, because based on the reading of it, defense counsel was in agreement that there was no program available. The defense counsel didn't come in and say, I want to put on proof that my client is eligible for community correction. He conceded that there was no, I don't have a program for him. So it wasn't a situation, I think this is both, I think both the defense counsel and the court were saying there's nothing available. And there wasn't an argument. There wasn't this proceeding farther to say that it's wrong, that there's not something available. Judge, let me put on proof to show my client's eligible, well, more than eligible, would get community corrections. And then, you know, Your Honor, I want you to craft something for him. I mean, it was just basically thrown out that there's nothing available, therefore, Judge, you can't put him, there's nothing to put him on. I mean, that seems to be the way it went. And then we're going to start talking about this big constitutional issue that was never really discussed in the trial court. And so where does that put us?
I understand what Your Honor is saying. I think, though, you're ultimately in the same position if you had a defendant who was probation eligible and you had the trial judge ruling.
Not so. Not so. You have to request community corrections. My reading is, how is the trial court to know what section, under what section the defendant would have been if he wanted to put him, if he had a program, according to you? I mean, for me, I think you're putting an onerous burden on a trial court, if we agreed with you, to say every time a defendant is eligible that they have to go and analyze application of community corrections. And that's not the case. Otherwise, trial courts would be doing that. Every time you had a sentencing, you would attach community corrections to it, and each of the different subsections of the community corrections statute. And that's just not that's not how it works. That's not my understanding of how this works. But go ahead. I didn't mean to cut you off again. You want to address something.
But I think the trial court directly ruled that that community corrections was not an option.
That is not a ruling. That is not a legal issue. Because community corrections is not an option. There was no motion or application for the defendant to be placed under the subsection of community corrections that allows for housing of alcohol or drug-dependent individuals. There was no application for that. And quite frankly, my review of the record, which is why I kept asking you, is it is very questionable whether this defendant would have been given community corrections based on his violent prior history. So I'm just, a little concerned with how strongly your brief came in versus how weak the record is. But I'm going to allow you to continue.
Just so I can get this, the remedy that I believe is appropriate is for this case to be sent back to the judge for consideration. Yes, Mr. Patterson is eligible, but is community corrections placement appropriate? If the court says community corrections placement is not appropriate because of this prior history, then the issue's gone. If the court says community corrections placement is appropriate, but I don't have a program, that's when we reach the problem of it's unconstitutional not to place Mr. Patterson on that program under equal protection due process. The criminal court, I believe, has jurisdiction to remedy that, not by ordering a community corrections organization into existence, by placing an order that would prevent Mr. Patterson from being disadvantaged by the absence of that. You can construct something very similar to community corrections through probation, conditions, use of community correction statutes for calculations. And the court, I believe, has the ability to avoid a constitutional disadvantaging for Mr. Patterson.
Well, let me just, I know we're running out of time, but having been a trial judge, and I can tell you, if there are no programs available, I can't create a program. If someone needs, and I used to deal with this, if someone needs in-house treatment and there is not anything available, I can't order them to go into a program that doesn't have bed space or do something. I mean, there's a limit. You're limited by what money and what partners are available. And if there's no partner available, I can't. The judge can't create one. That's why I think we're all going to wind up at the same place. Anyway.
Let me say one last thing, and I promise I will sit down. It is my belief and my position that who goes to prison, what categories of people go to prison, should be determined by the legislature and by the trial judge. Here, neither the legislature nor the trial judge decided that the correct thing for Mr. Patterson was to go to prison. Something else happened, and that's not okay.
Thank you, Mr. Harwell. The matter will be taken under advisement. I need to take about a 10-minute break, Madam Clerk. If you could recess us.
All rise.